Hello everybody, my name is Widyarini Indriasti-Wardani. I am from Universitas 17 Agustus 1945 Semarang. I want to present to visiting professor about Ulayat Rights as a inherited land right of Indonesian nation that need legal protection. Introduction. The Ulayat rights that have been owned by customary law communities for the centuries, even long before the realization of the Republic of Indonesia, will become a legacy for the Indonesian people if they do not receive definite protection. The protection of customary rights for the customary law communities by the Indonesian people through land law politics, which is carried out sustainably, cause customary rights to remain owned by customary law communities and will not be destroyed, which will only become a legacy for the Indonesian people that they were customary rights in Indonesia. The protection of customary rights owned by indigenous people is also regulated in several international treaties which are part of human rights, both individually and in groups. ILO Convention 69 has established several important indigenous people's rights, such as free and informed consent, consultation, and compensation. The United Nations Declaration on the Rights in Indigenous People, UNTRIP, is an important document for the international recognition and protection of the rights of indigenous peoples. The declaration recognizes collective rights, including the right to self-determination and the right to cultural heritage and intellectual property. Introduction. The politics of land law in Indonesia related to Ulayat rights has experienced ups and downs and is strongly influenced by government holders as policymakers, especially regarding the access of the Ulayat rights. Ups and downs in this case mean that customary rights to obtain protection by the government are not continuously and consistently maintained as land belonging to customary law communities. Formulation of the problem. Based on above background, the research raised the formulation of the problem is this study as follows. 1. How is the exercise of the Ulayat rights as the inheritance of land rights of the indigenous peoples in the framework of the national agrarian law? 2. How is the protection of Ulayat rights as inheritance of land rights of indigenous people in the framework of national agrarian law? Research methods. The research method in this research is using normative judicial research, namely the doctrinal law research method by reviewing the provision of the applicable laws and regulation as a basis for the later analyzing the problem study. This research is descriptive analytical, using primary legal materials and secondary materials through the study of documents and related literature. Analysis of the data used in this study is a qualitative analysis to answer the problem studies. Discussion. 1. The existence of the customary rights in Indonesian agrarian law politics. The laws and regulations in Indonesia recognize and protects the existence of customary rights in line with recognition of the international provisions. This recognition is contained in United Nations Declaration on the Rights of Indigenous Peoples, which was adopted by the United Nations General Assembly in its 61st session at United Nations headquarters in New York on Thursday, September 13, 2007. with 144 countries supporting 4 against and 11 absent. There is one new hope that can still be put forward, namely regarding protection by regional governments, because regional government can make regional regulation whose purpose is to protect the rights of indigenous peoples. One which is West Sumatra regional government, which has retired with regional regulation number 6 of 2008 concerning Ulayat land and its utilization. One, the objective is to prevent conflict between communities regarding this Ulayat land and also the provide legal certainty. Number 2, protection of Ulayat rights or heritage communities' rights as the inheritance of land rights of the indigenous peoples in Indonesia. Article 18B, Paragraph 1 and Paragraph 2 of the 1944 Constitution have been amended declaratively by recognition and respecting the existence of the customary law communities and their customary rights, although with several recruitments that are not much different from Article 3, Paragraph 1 and 2 Law number 5 of the 1960 concerning UPA, namely as long as it is still alive or existing. B, following the development of society. C, following the principles of the unitary state of the Republic of Indonesia. D, regulating by law. Historical, customary law communities and their Ulayat rights hardly uphold the external sustainable of nature, so that its utilization of the environment, natural resources are also very natural by paying attention to the preservation of the natural environment. Closing. 1. The existence of Ulayat rights in customary law communities is a historical heritage of the Indonesian nation that has lived for centuries. Ulayat rights are land rights that are formed spontaneously and are communal. It is communal because the owner of Ulayat rights, namely the customary law community, whose members have an inner bond between one member and another. This has the effect that if other parties are not members of the group, they cannot use land that is already owned by the legal communities group. Indigenous people have power and authority over the land they own, forest, and control. This is what is called Ulayat rights. Number 2, the protection of customary rights as an inheritance of customary law community lands has been implemented by the government through Article 18B, Paragraph 1, 2 of the 1945 Constitution, which has been amended with declaratively protects by recognizing and respecting customary law communities and their customary rights with several conditions, namely as long as it is still alive or exciting according to the development of society, following the principle of the unitary state of the Republic of Indonesia and regulated in the law. Article 18, Paragraph 1 and 2 of the 1944 Constitution should not be accompanied by discriminatory recruitment, so that the existence of the customary right is still recognized, respecting, protected, and likened with other land rights. The area of customary land rights of the customary law communities is identified either communally or individually. Thank you. Nah,